and welcome to a Newsflash episode of Unpacking the Case, the podcast by Davitt Jones Bould, the real estate law specialists. As always, I'm joined by our head of legal training, Richard Snape. Hello, Richard.
Hello, Lizzie. Anything been happening since we last spoke?
No, we just finished a webinar about 20 minutes ago, so we've just had a quick break and we're back at it. Mm-hmm. So we're back to talk about a new Upper Tribunal case from the 26th of June called Stenner and Teignbridge District Council. And this is all about easements and exclusive possession. So do you want to tell us a bit about the background of the case to start off?
Well, yeah, it was, it's in Teignmouth. You know Teignmouth, don't you, Lizzie? West Country girl. It's amazing how many cases I actually know the very spot. I'm pretty sure I do. It was Lower Point Car Park in Teignmouth, which was the subject matter owned by the council, or the freehold was with the council. There were a row of beach huts just by it, including 3 beach huts where the freehold was owned by Mr. Stenner. And Mr. Stenner was in the summer months. He was doing boat trips and the likes, from Teignmouth. But in the winter and autumn months, between basically, the boats would be between beginning of May and the end of September, and the rest of the time they would just store these boats, between the beginning of October and into early May. On the Lower Point Car Park, a specific piece of land was described as the Triangle, and they would store 6 boats there for the out of season time. And he started doing this in 1982, and in September of 2021, they applied to the Land Registry to have the easements registered, both the benefit and the burden of the easements registered. So the question really is it an easement? And the first tier tribunal heard the case, and the registry presumably sort of sent it to the first tier tribunal for a decision, and decided it couldn't be an easement. It didn't fit the characteristics of an easement. Although they did decide that an easement could have been created through prescription on this occasion, which I'll perhaps mention a little bit about. But it wasn't capable of being an easement in the first place. So that was all irrelevant. And this was the appeal decision, the Upper Tribunal, as you mentioned, on June the 26th.
So can you tell us a bit about the background law around easements?
Yeah, well, there's 2 issues involved. I mean, I'll do them in the same order as in the case. Firstly, whether an easement's actually being created by long use prescription, which wasn't discussed in that much detail, I think quite wisely, but you're sort of following on from the first tier tribunal. We've mentioned it in podcasts before, but a prescriptive easement's got to be based on acquiescence and long user as of right for the prescription period, which, I won't go into the details, but basically 20 years. As of right being without force, secrecy and permission. We've done a very recent case on that, Atkinson and Brown. But it's also got to be a degree of continuity of the user. It's got to be by or on behalf of and against a fee simple, but that wasn't an issue. And one of the questions was, is there a degree of continuity? Because, for the winter months, you weren't storing these boats. And the tribunal decided quite rightly that you didn't need continuity sort of all the time. For the summer months in the late spring and early autumn, that was sufficient. I mean, I can think of numerous cases. I can think of prescriptive rights to claim village greens based on lawful pastimes and sporting activities, based on things like, kite flying and also sledging, not in the cricketing sense, the ancient custom of standing behind people, slagging them off, but giving them verbal abuse, but in the going down a hill in the snow. And that doesn't happen that often. So there was no issue there. If it was capable of being an easement in the first place, then it could have been created by prescription. But the main question is it capable of being an easement in the first place? It brought in quite a lot of issues that we've talked about over the years. They didn't quote it, but Ellenborough Park, Western Supermare's finest hour, from 1956, where the laid down the four characteristics for something to be capable of being an easement. Firstly, there's got to be a dominant and serving piece of land. Unless you own a piece of land, you can't claim an easement. And secondly, the right you're claiming has to accommodate and benefit the dominant land. And they decided that wasn't a problem because Stenner owned the freehold to these 3 beach huts. And that was the benefited dominant land. So the first 2 characteristics are met. There's got to be diversity of ownership or occupation. That's clearly the case. There's diversity of ownership and occupation or occupation on the land. Stenner didn't have any freehold or leasehold interest in the land. But fourthly, the right must be capable of forming the subject matter of a grant, and that was the real issue. Because one thing that easements have to have, there can't be ouster of the actual dominant owner. An easement's the right of that you have over another person's land, and if you exclude that other person from the land, then it can't be an easement. If you want an estate, if you want a property right that binds third parties and gives you exclusive possession, that's what an estate in land gives you. You're the freeholder or you're the leaseholder, but it can't be an easement. And there's been lots of cases over the years on primarily things like storage and car parking. I'm actually quite famous for this, my knowledge of car parking easements. Did you know?
What a thing to be famous for.
Yeah, well, it's what I'm going to have on my grave. Because I was the one who popularized some of these cases when I started doing this as my main job in the early 2000s. Shall I tell you some of the cases?
Yeah, what other cases are there? You've already mentioned a few.
There's the first case actually was a case called Copeland and Greenhall, or it's spelled Half, but I've never known how you pronounce it. I was always told on degree, and it was Greenhall, and that stuck with me. But in the 1950s, and it was about storage of agricultural vehicles on a stretch of land. And the court in that particular case said that this can't be an easement because it's exclusive possession. You're excluding the purported dominant owner from the land. And that was much quoted in this particular case, Copeland and Greenhall. There have been other cases about storage, which there was a case called the Wright and McAdam, for instance, which from 1949, I think, which was said you can have an easement for storage as long as you're not sort of ousting the dominant owner. You're not using all the land for storage. And there was another case which wasn't quoted in this one, Miller and Empser Products, which is my favourite, 1956, which was you could have an easement to use a toilet, a neighbour's toilet. Could be an easement, even though they recognised that there would be exclusive possession, albeit for short periods, one hopes at a time. The main batch of cases were about car parking, though. And there was a case in 2001, a Court of Appeal case called Batchelor and Marlowe, which had, these people had a garage, and there was it was a highway, but it doesn't seem to be tarmacked or anything. And the other side of the highway, not part of the highway, I stress, was a stretch of land where they would store vehicles pending doing them up in their garage. And they've been doing this for many years, and they claimed a prescriptive easement of storage. Of car parking. They only parked between, when opening hours between 8:30 and 6 in the evening, and 8:30 in the morning, and not at weekends. So the majority of the week they wouldn't be using for parking, but when they were using it, it was such that it wouldn't be reasonable for the paper owner to actually use the land. And that was decided it can't be an easement. There's exclusive possession, albeit for only a part of the day. When there's exclusive possession. And it was a Court of Appeal case. There were then cases, which there's one they didn't mention actually, because it's just around the corner as well. There's a case from Torquay called Newman and Jones from 1982. It's never fully reported, which is parking on cars in a forecourt of a block of flats. And they were parked on a first come, first served basis. There were more flats than parking areas. They weren't laid out spaces. They decided that could be an easement because there's no exclusive possession. Collectively, you might be parking on over the whole of this forecourt, but you're not guaranteed a space. And there was a case called Montrose Court and Shamash as well, near the Albert Hall. where they were doing a similar kind of thing on a private road, and that could be an easement because there was no exclusive possession. But Batchelor and Marlow is probably the most significant case. Unfortunately, and they discussed that's not that much. There was a case, a Scottish case. It was heard in the House of Lords in London, but it was a Scottish appeal case called Moncrief and Jameson in 2007, which was all about parking in the Shetland Islands. They seem to have had a property which was on a cliff in the middle of nowhere, and they purchased an access way, tarmacked it and so on, to get to, so they could drive to their cottage on the cliff. But their joy turns to horror when they realise when they get there, there's nowhere to leave the car at the end. And it got to be a neighbour dispute that got out of hand and ends up in the House of Lords at great expense. And the House of Lords said it must be implied you can leave your car at the end of the driveway if you've just bought access across this driveway. But one judge, Lord Newberger, stated that they thought that Batchelor and Marlow was wrong. Both counsel in this particular case, in the Teignbridge case, basically accepted that Moncrief and Jameson was not a binding precedent, being Scottish. And actually, it wasn't quoted, I don't think, anyway, but there was a case called Verdi and Charner in 2008, which had said that anyway. It's not binding in England and Wales. But there was attempts by Stenner to argue various other cases, as a question of degree. A case called Dillaquona and Big Apple Marketing, which was about parking in a space from 2017. But when you weren't parking there, other people couldn't park there, but they could walk across it and they could drive across it. And the freeholder sort of reserved the right to put advertising hoardings on the side of this particular space, and remove you on management grounds if you want to, sort of tarmac over temporarily. You could be moved about, which tends to be the norm in flats nowadays. And that could be an easement. They said there's no exclusive possession. There's also a case called P&S Platt and Crouch from 2003 in the Norfolk Broads, where moorings could be an easement because you weren't mooring there all the time. So the whole thing is a question of degree. But they decided in this particular case, do you want to know the decision?
Of course, yes.
They followed the first tier tribunal. There was attempted arguments by Stenner that people could walk between the boats and so on. And also they tried to argue, I think, a bit of a non-starter, that you could still have services, drains, cables underneath the land and so on, so it was not completely ousting. But a bit like Batchelor and Marlow, and basically in Copeland and Greenhall, they said that to all intents, during from May to end of September, you can't, the council, the freeholders couldn't use this land. And therefore it's ousted and it can't be an easement in the first place. Yet another example.
So why is this one significant then?
Well, it's just a reiteration of things we knew already. I mean, if you've got exclusive possession, it can't be an easement, and it needs to be an estate in the land, as I mentioned. Well, I mean, it's important. I mean, the car parking cases are extremely important. I mean, based on all the cases that we've got, if you're parking on a first come, first served basis and it's called an easement, let's make it a leasehold, like block of flats or something like that, it can be an easement. And if it's in the schedule of easements, it can be an easement. On the strength of some of the cases, because it's a question of degree, Big Dillaquona and Big Apple Marketing and P&S Platt and Crouch, then if you can be moved on around on management grounds, there's not exclusive possession, which is, as I mentioned, the norm in blocks of flats nowadays. That can be an easement. If that's your space you're claiming, and that's it, that's your space, full stop. Can't be moved around and so on. No matter what it's called, it can't be an easement. And it's not a property right, it's a mere contractual license or a license to be there, not necessarily contractual. And it won't bind third-party purchasers. Bought the reversion of your block of flats. I mean, the other one is there was a case called Penina and Moreland in the year 2000 where they tried to argue an easement to exclusive use of a roof terrace. which you frequently see, things like exclusive use of a roof terrace, not demised. It'll be an estate agent's particulars. And it was held because it's exclusive, it can't be an easement. Why they don't, wasn't the facts in Honey there in Moreland, but why developers don't demise the roof terrace is because they have a hope of building upwards one day and evicting you from the roof terrace and selling the property, selling the reversion, which is what they do, to somebody who can build upwards. It's quite a significant little principle.
Brilliant. Thank you very much, Richard. Thank you very much, Richard, and thank you to everybody for listening. We'll see you again in our next episode.